This is Law with Charlie, hosted by Charlie Medcalf. This is your podcast and YouTube channel for all things law, legal academia, and qualifying as a barrister.
Hello everyone and welcome back to this podcast with me, Charlie Medcalf. This is Law with Charlie. And I wasn't really expecting to do this episode this soon, but here we are. It is currently Tuesday the 2nd of December 2025. Exactly a week since the leaked government memo from David Lammy regarding jury trials, and you can listen to my podcast on what a jury is in my previous episode, but I will also recap it in just a moment. But the reason we now find ourselves in this situation where we need to talk about it today is that we have heard today it be announced that juries are going to be abolished for all but the most serious crimes, and this is not a welcome change and is potentially looking like the freedom, the value of our justice system and everything the justice system has stood for may be coming to an end, maybe collapsing sooner than we would have liked, and that maybe it's the government, the executive as they're called, going a step too far. But just to remind you that a jury is a group of 12 people who are selected at random based on the electoral register, and they decide a verdict in a criminal case where the defendant pleads not guilty. So essentially they will listen to all the evidence and then they will either come up with a verdict which is either guilty or not guilty. Now, there are 3 different types of criminal offences. There's summary offences, either way offences, and indictable offences. For summary offences, only magistrates give the verdicts, and there is no right to go to the Crown Court or higher. With an either way offence, magistrates or the defendants can choose to go to the Crown Court. For indictable offences, so those things like murder, rape, some drug offences, etc., they must be tried in the Crown Court. And there's lots of information I could go into, but just to keep it simple, it's only with either way or indictable offences that jurors may be permitted, and it's only if the defendant pleads not guilty and if there's no risk of the jury being biased, contaminated by the defendant or so on. But there's only very, very, very exceptional circumstances where a jury wouldn't be allowed in such a situation. And there's often been this idea of lay people coming together to investigate crimes, and it has been said that it rooted in the late Saxon period. So rather than the court type of system we have at the moment, individuals would come together and then they would look for evidence, they'd question each other essentially, and that was the previous jury, but it's really developed since then. And in 1215 the Magna Carta further sets out this as a right to justice, and we then later hear, many more years down the line, by Lord Devlin, a senior judge, who wrote in 1956 that a trial by jury is more than an instrument of justice and more than a wheel of the Constitution. It is the lamp that shows that freedom lives. And so now that the right has been taken away from most offences, does that show that freedom no longer lives? Now, I suppose when you look at it in response to previous government changes with the most recent Labour government, who are still in power, it is looking that way. So there's been concerns over the digital identification brick card and the consequences that may have, and that might just be a way of taking away freedom, and that's just one of many examples. And so this is a really problematic piece of news, and I will likely be doing more content on whether we still have freedom in 21st century Britain in the near future. But just for context, one of the main reasons given to us by the government for this radical change is the large waiting times for the criminal courts. Apparently there are currently 78,000 cases waiting to be heard at the Crown Courts in England and Wales, and this means that some suspects won't see justice until 2028 or 2029. And so I'm going to be going through essentially the BBC article on this matter and offer some of my own views and some criticisms, for instance. And so part of this reform is that Lammy proposes to create some swift courts. And so they're essentially courts which lie between the Magistrates' Court and the Crown Court with jury. And essentially, the swift court, as it's been described, will be a place where it's decided by a judge and no jury. And there has been mentioning of 2 magistrates also sitting with the judge in that situation. And that would be similar to the situation when there's an appeal from the Magistrates' Court. So there's loads of different rules when it comes to appeals, but put simply, if a defendant appeals from the Magistrates' Court, that appeal is heard by a Crown Court judge in the Crown Court alongside 2 members of the magistrates. And so, essentially, the swift court is going to take that kind of model. And so, at this point, I think it's unclear how easy it will be to appeal, or if that right will even be allowed. Because if that right is allowed, does it go to the Crown Court or the Court of Appeal? And essentially that's just going to lead to even more delays. And as I've said in previous content, the problem with all these delays is not the jurors, it's everything else. And these reforms, which I've seen, is not going to change the actual underlying causes. Apparently, Lammy did manage to avoid taking some of the more drastic reforms, and so at least that's a bit of a positive. But in the proper Magistrates' Court, the one above this swift court, it will be a court where the most serious offences are tried, and this includes murder, robbery and rape, and they will still go before a jury, to name just a few. But also volunteer community magistrates will be able to deal with the majority of all criminal cases and take on even more work. So a question on this thing about the magistrates. All the criminal cases start in the Magistrates' Court. The vast majority of them end in the Magistrates' Court. I do not know of the percentage off the top of my head, but when you look at the statistics, only a very small proportion of cases actually get to the Crown Court for a trial. And so this is one of my first concerns, and it goes back to everything I've been saying. If the majority of cases are in the magistrates, does that mean the problem is in the magistrates? And if so, what's being done to overcome those problems? Not a lot, and not the right things, I would suggest. Furthermore, although I do admit that some things in the Crown Courts do lead to delay, it's often not the jury. It's often things like witnesses not showing up, the defendant not showing up, if the defendant is in the police. No, not in the police. If the defendant is in prison, sorry. It's when the prison transport doesn't get to the prison or doesn't get to the court on time. A ridiculously regular thing, which, yeah, it shouldn't be happening at all, but it does. Yet, those real problems are not being considered. Then, some criticisms about magistrates. Magistrates are criticised because the majority of them are white, old, and it's been suggested that they are more upper class or middle class. Why is this a problem? Firstly, many of the people who come before the Magistrates' Court are young people. And as young people, because I'm young myself, at least I would say so, We are a different generation. We are the first generation who have really grown up with technology, for instance. Times have changed dramatically since the childhoods and young adult lives of those who are magistrates. And so the argument is with magistrates, they're meant to be representative of the people who come before them. But actually, if they are all much older, is this really the case? Also, there's a disproportionate number of black and ethnic minority individuals who find themselves in the criminal justice system. And this can again be problematic when the majority of magistrates are white. And then, so they are just some of the problems. They don't have any legal experience either, as such. They're old, and they're white, meaning it's not really representative. And to build on that approach, they say that they're going to give magistrates even more work. And I've just mentioned how maybe magistrates are not that representative. And he might turn around and say they could recruit more magistrates. Magistrates aren't costing them much. Magistrates do the majority of their work for free. They're volunteers. Absolutely right, you are. You might also, if you're particularly observant, notice how there's often radio adverts, TV adverts, or whatever other advert in whatever other form asking for magistrates, trying to recruit more magistrates. And as a law student, I have been interested in signing up as a magistrate before I qualify, because I think it could be a good way to gain experience. However, would you believe it that despite all these adverts which go on, when I've been on the Magistrates Court website to look at any vacancies previously, there's been nothing available, or at least very, very little available. And so that is one of the biggest criticisms when it comes to magistrates. They're not recruiting them. And so we're not going to make this system any better. If anything, the system is probably just going to be more constrained and more stretched than it already is. Furthermore, many of the cases which magistrates deal with are strict liability cases, meaning, well, let's take it back to the very, very basics. For the majority of criminal offences, you need two to three elements. The two key elements is the actus reus, which is the guilty act. So let's say this was a murder. The actus reus would be me stabbing somebody through the heart, for instance. And then the second key element is the mens rea, or guilty mind. And that would be the intention for me to stab the knife into somebody's heart. So the two main elements are actus reus and mens rea. But then there's also a need for a lack of a defence, but that's another area of law altogether. With strict liability offences, an actus reus is required, but the mens rea is not required. And many of the cases I have observed in the Magistrates Court have been strict liability cases. And there's so many cases where I personally think that these individuals should not have been convicted. It's been unfair on them and their circumstances. I'm talking about individuals who were helping their elderly relatives who get to hospital, shop, etc. I'm talking about individuals who are trying to protect family members from mental health crisis, including self-harm and potentially even suicide. And the two cases I have just mentioned are based on two cases I have actually seen in the Magistrates Court, which I strongly believe the magistrates dealt with wrongly. There's been times when I have honestly thought that the magistrates would acquit some of the defendants who appear before them, but I was so very wrong. And so, if it's in front of a jury, is it likely they're more likely to acquit such individuals? Will the jurors be able to emphasise with the people rather than the law and actually think, actually this person was doing something which was good. He or she potentially saved someone's life, for instance, and so maybe they will say not guilty on those facts. That is something juries are allowed to do technically, and they do it occasionally. Again, another area of law altogether. But yes, with the magistrates, it feels like there's going to be much more limitations, and that actually the system as we currently know it is just not ready for these ideas. And if this is going to be the thing, more work needs to be put into magistrates, both training and recruiting more people who are more representative, and maybe even relaxing the rules around who can volunteer and when, for instance. Some of the other reforms which were suggested by Sir Brian Leveson, who was a previous High Court judge who came up with a report and loads of proposals, is the need for more out-of-court settlements. And this is something I very much agree with. If we can tackle more cases before they get to court, that is something we absolutely must be doing. I know in the family courts there is a really big push for mediation and anything other than going to court, and especially with some of the things which come up in the family courts, again based on my experience in my various roles, individuals, parents will go to court asking the court to just edit an order, for instance, and the courts really do not like this. The courts would much rather something like that is done at mediation, and so it's making use of these out-of-court settlements much more, and that would be a very positive step. The same is similar with the employment tribunals system. In the employment tribunals, you have to first at least attempt some out-of-court settlement, and then once you've made that effort, ACAS will then provide you with a certificate which allows you to go to the tribunals if you still think that's necessary. And so, essentially, out-of-court settlements is very much a thing we should be pushing for. But again, as I keep saying, a lot of stuff needs to be reconsidered, i.e. the abolishment of juries, and also how all of this is going to change. And so, apparently, Lammy says this new system would get cases dealt with a fifth faster than jury trials. Whereas, to be honest, I am not convinced. It might be slightly faster, but I can't see it being that much faster. But Lammy also added that it was necessary as current projections have Crown Court caseloads reaching 100,000 by 2028 from the current backlog of almost 78,000. Now, I'm going to come up with my suggestions for reform and ways to overcome this problem in future episodes. But one of the main reforms, which I'm going to mention briefly now, is law students wanting to train as barristers. There are so many law students who want to train as barristers, yet there's so few places for these individuals to actually train, and as such there will be thousands of individuals each year getting to the stage just before they can practice in the journey to be a barrister, and only a few hundred will get selected. And this is very problematic, and this is fueling these delays. And so I'm going to discuss in future episodes how aspiring barristers should be used more in such cases in order to help reduce the caseload of the courts. At the moment, the government are not working smarter at all, and the move they've announced today has been a very stupid move in my opinion. And then another fact which is mentioned is how 6 out of 10 victims of rape are said to be withdrawing from prosecutions because of delays. Now, you can't say this is just because of delays, and there's many reasons why victims of rape may want to no longer provide evidence. And to be honest, this could be criticisms of pre-trial processes as well, because rape victims do not need to be going to the trials in all the circumstances. They can have their examination in chief recorded. They can have their cross-examination and re-examination recorded, meaning if this is done much sooner, then they do not need to be worried about the rest of the cycle, and their evidence can be played to the jury or whoever might be in the court under these new reforms, and that prevents them from needing to come to court and may even discourage them from withdrawing. But to blame 6 out of 10 rape victims from withdrawing just because of delays is not fair. Lammy also mentions how these reforms will prevent defendants from gaming the system, but I think that's really unfair as well. This is looking like a criminal justice system which is trying to convict, and that's very much been the case, and jurors haven't been brilliant at stopping that, although there's at least one more barrier in between conviction and acquittal. So the BBC article goes on to mention how there's around 1.3 million prosecutions in England and Wales every year, and only 10% of those cases go before a Crown Court. Of those, it's 3 of 10 which result in trials. And so this really goes on with what I previously said earlier in this podcast. Jury trials make up a very, very small proportion. 3 out of 10 will go to trial, which will require a jury. 3 out of 10 Crown Court trials will require a jury. And so this reinforces my argument that actually abolishing juries in these cases is not going to do much. And I think I've previously mentioned in my previous episode, barristers, law students like myself, the Criminal Bar Association, the Bar Council of England and Wales, everyone is very much against it, and in some of my subsequent episodes I'm going to go into more detail about what barristers and others have said on social media. And it has even been said that how Lammy has previously said that cutting jurors would be a mistake, but he has said that the facts have changed. This is really concerning. Cutting jurors would always be a mistake, and even with these delays, it's not justified. Now, according to the BBC article, the Shadow Justice Secretary, Robert Jenrick, accused Lammy of scrapping the institution he once lauded. And he went on to tell the Commons that why on earth does this Justice Secretary think he has a mandate to rip up centuries of jury trials without even a mention of it in his party's manifesto? Now, this touches on some constitutional law, but yeah, this is such a radical change that more notice needs to be done about it, and to be honest, it should have been brought to the people, whether we as a people in a democratic society think juries should remain or be abolished. And I think the majority of people would want juries to stay. And as I've previously mentioned, it's not the juries. It's reduced court sitting days. It's closing down court buildings. It's everything but the juries which are causing this problem, which is very, very problematic. Now, one solicitor advocate, Abigail Ashford, mentioned how judge-only trials risk deepening existing inequalities and eroding confidence among communities who already feel marginalised. This is a real concern because the judiciary have historically been accused of being male, pale and stale, as it's called. So the majority of them are male, the majority of them are white, the majority of them are much older, and the majority of them historically have been from Oxbridge. This has now changed quite a lot, but there's still so much more which needs to be done. And yeah, these criticisms just go on and on and on throughout the legal profession, and so it's just more and more concerns. And so it's going to be really, really interesting to see what happens next. And so I will keep you updated in terms of what does happen next, as well as continue this series. But looking through the BBC articles, it mentions how this has become the beginning of the police state. Absolutely. I've started reading 1984 by George Orwell, and it's scary just how close we are going to be getting to that. Someone else provides a quotation of Clause 39 of the Magna Carta, and they say, open quote, "No free man is to be arrested or imprisoned or deceased or outlawed or exiled or in any way ruined, nor will we go against him or send against him except by the lawful judgment of his peers or by the law of the land." And so, this is, as you can probably tell, this is extremely problematic, and this is going to have a real damaging impact on our criminal justice system. And it's going to be really, really interesting to see how public attitudes towards the criminal justice system actually change, and what this is going to mean for the long term in terms of cases coming to court, the criminal justice system, but also in terms of those who are qualifying as barristers and even solicitor advocates. I honestly think, and I might be biased as an aspiring barrister, that there's much more the judiciary can do, and there's much more that the government, the executive, can do to make law students, certain law students, not all law students, and I will go into much more detail about this in a subsequent episode on my suggested reforms. But there's much more use that can be made of law students which could support their training and actually help them become barristers. Because the problem, I would suggest, from all this news isn't necessarily that we do not have capacity for barristers. For those of you who may not know, barristers are self-employed, the majority of them. And so the problem is trying to find the chambers, which a barrister needs to be part of, to take you on, to provide you the final part of your training, and then to give you tenancy. There's limited capacity in chambers. That's where the problem is. And so I will discuss this in more detail in a subsequent episode, as I keep saying. But it would be interesting to consider how this may impact the criminal justice system if we looked at reforms around legal advocates. Because surely, if we had more legal advocates, there would be less delays. But also, we need to look at reform more holistically as well, and actually maybe consider reversing David Lammy's recent decisions. Now, I will end on a slightly more positive note. I'm not sure when the next general election is actually, off the top of my head. I'll just do a quick search. When is the next general election, UK? And the next general election is going to be apparently no later than Wednesday the 15th of August 2029. And so, just do a bit of maths in my head. So that's about 4 years away now. So yeah, I think it's about 7 years between general elections. No, 5 years apart, sorry. And the Prime Minister can call one earlier, which I think it's highly unlikely Keir Starmer will call an earlier general election. But when the general election comes, if the Democratic Society vote in a new political party, and as a result a party other than Labour becomes the next government, then they do have the constitutional rights to make or unmake any laws of its predecessors. And so once we get a new government, if we get a new government, that new government can restore the right to jurors as we have previously known it, if they so wish. However, I do not know how likely this is going to be, and so it's going to be interesting to see what public attitudes are. So, if you've got this far, you are obviously very interested and probably even as concerned as I am about these reforms, and so please do let me know in the comments below what you think and if you have any questions. But I think that's about all for this extra episode today, and I look forward to my next podcast episode very, very soon. Goodbye.
Thank you for listening to Law with Charlie, with your host, Charlie Medcalf. Please do ensure that you leave a comment below either to just say hello or ask a question. And please like, subscribe, and leave a review for more content like this. See you next time.